Next case on the docket is TRAINOR versus PNC Bank.
May it please the court. Counsel. Good morning. My name is David Russell with the law firm of Pappas & Russell, appearing today on behalf of the appellant in this case, Janet TRAINOR. This case arises from a trip and fall incident that occurred in the parking lot of a PNC branch location. My client, Janet TRAINOR, was making a deposit at the conclusion of her work day. She was attempting to make that deposit at
Try and speak up just a little bit.
Ms. TRAINOR was attempting to make that deposit at an ATM at the PNC branch location where she conducted her business. And when she arrived, she encountered a area of construction and a barricade directing her to walk around this area of construction. And in doing so, she walked across a pothole in the PNC parking lot, tripped, broke her leg, and fell, causing additional injuries. My client below filed a complaint alleging counts for alleging theories of negligence under the breach of the duty to maintain, breach of the duty to warn. And the trial court entered a summary judgment in favor of the appellants, finding that the condition at issue in this case was open and obvious, discharging both the duty to maintain and the duty to warn. And that's the central issue here on appeal, is whether or not the trial court was correct in its conclusion that the obvious danger doctrine discharges a landowner, the owner or occupier of land's duty to maintain its premises in a reasonably safe condition and warn of any hidden dangers contained on the premises. Our contention is that the condition at issue in this case is a pothole. Now, there's some contention below about whether or not it really is a pothole or not, but this seems to be a matter of semantics, really, because it's clear from both my client's testimony, the only record evidence in this case is that my client describes it as a pothole, the pleadings describe it as a pothole. The image that was attached to the PNC's motion for summary judgment indicates a portion of the asphalt that's in a state of disrepair. And so when you look at this court's precedents, there's a clear distinction drawn between these natural conditions, such as one of the primary cases that PNC relied on below, which is the Circle K case, where you have a cement covering over gasoline tanks meeting an asphalt parking lot. And the court in that case found that there are some conditions that are so open and obvious, so innocuous, that they cannot be deemed inherently dangerous as a matter of law. That's not what we have here.
Circle K case, though, seems to me to certainly have some parallels here. Circle K, you have white concrete, blacktop, and a poor joint, an imperfect joint, whatever the court called it. Here you've got black asphalt, and looking at the pictures and the descriptions, a white defect, whether it's a pothole, a tear, I don't know what you want to call it, the thing that she stepped into. I mean, they're both kind of black and white, if you will.
Well, I think that if the court were to apply the Circle K case here, for one thing, the Circle K case, that was a case involving a directed verdict. And the sole issue, apparently at the trial court level, was whether or not the defendant had breached its duty to warn. And if you look at the cases that are cited in the Circle K case, it specifically refers to a Supreme Court case which dealt with whether or not a landowner had breached their duty to warn. And so what the Circle K case holds is that if the condition is open and obvious, then it cannot be held to be a hidden danger. And
that doesn't get rid of the duty to maintain.
Correct, Your Honor. And that's exactly my point. And if we look at this court's holding in Turner versus Winn-Dixie, which is a very similar case to the case sub judice, and that is that it involved a pothole in a parking lot. And again, whether you call this condition a pothole or not, it's clearly a portion of the asphalt that had fallen into a state of disrepair. And this court clearly distinguished between cases like Circle K and then the planters in cases like Gorin and Taylor versus Universal, in that those are natural conditions not meant for walking. These are obvious conditions for which there is no duty to warn or no duty to maintain because they're not inherently dangerous. That's different. What we have here is very different, and this court has clearly held in Turner versus Winn-Dixie that this can be a dangerous condition, and it's a matter for the jury to decide. So our position here is that Turner versus Winn-Dixie applies as binding precedent on this court. This court should follow its precedent and reverse the summary judgment that was entered in this case. And if there aren't any additional questions, I'll reserve the remainder of my time for rebuttal.
Okay, you want to save the remainder of your time? Okay.
Yes, Your Honor.
I understand that the parties wanted to divide their time. Would you tell me how you want to do that again? I understand that you filed something, but just tell me again.
Sure, Your Honor, and that's what I was going to address first. I'm going to handle the substance of the open and obvious nature of the issue here, which was covered in PNC. I represent PNC Bank. That issue I'm going to cover. Counsel for the third and fourth party defendant, I think only one of them is going to argue, but they're going to do...
How much time did you...
15 minutes for me, and then they're going to have 5 minutes to do the tipsy coachman doctrine argument, I believe.
Okay.
All right. May it please the court, counsel, as I announced, I'm Daniel Leibowitz. I represent...
I just want to make sure of the facts. I understand that in this particular case that there was barriers and that there were directions or markers indicating where a business invitee was supposed to travel. Is that basically correct? In order to get from one place to the other?
Your Honor,
that this particular business invitee was traversing that route.
The ATM at this location was under construction. It was being moved down to comply with ADA compliance. There was, according to testimony, a sign there with an arrow pointing in the direction around which the plaintiff, in this case, Ms. Trainor, did traverse.
Okay, she followed that arrow, and essentially we can call that an instruction or a direction, right?
Well, I would submit to you, Your Honor, that's irrelevant for the reason that Ms. Trainor testified that she was going to make a deposit at the bank. She was trying...
Was she traversing the route that was directed by the arrow or not? That's my only question.
She was, and she...
Right, and then she encountered this condition.
Correct.
All right. And the trial court said that it was an open and obvious danger and that she should have seen it, and therefore there's no liability. Is that correct?
That's correct, Your Honor.
All right. In order for it to be an open and obvious danger, there must be some condition that's dangerous, right? Or that's not reasonably fit for safe traverse. Is that basically correct?
That's correct. Yes, I mean, at a minimum, it could be dangerous.
You directed the business invitees in a direction towards what we will say is an open and obvious danger.
Well,
Don't you then have a duty to ensure that if you're going to direct people, especially business invitees, if you're going to direct them in a direction and on a path, that you undertake the duty to make sure that the premises are reasonably safe for these people to traverse?
all right. First of all, Your Honor...
If that's the case, how does the open and obvious dangerous doctrine negate that duty? I guess that's the problem I'm having with this case.
I understand, Your Honor. And the answer is, first of all, my client is PNC Bank, did not have anything to do with the direction that was posted on that sign. Okay, that was done by a construction company. But it doesn't matter, Your Honor.
Is your client the property owner or not?
It is, Your Honor.
All right, so included on your client's property is an arrow directing business invitees in a direction where we have an open and obvious danger. And they're supposed to traverse that area.
I'm sorry, Your Honor, I couldn't hear that.
Is that right or not? I mean, it seems to me like that's what the facts of the case are, and it seems to me that if that's the case, and you're going to, I don't even think that you needed to have an arrow directing business invitees in a certain direction, but you did.
Sure.
And in this particular case, she traversed the area, followed the arrow, and encountered an open and obvious danger. And my question to you is, how does that negate the duty to reasonably keep the premises in a safe condition? And you're saying, well, you didn't put the sign there, but it was on your property.
Right. And I think, Your Honor,
I don't think that negates your duty.
well, I think that the duty is established by the law, which is the open and obvious nature, irrespective of whether
But
there
it
was.
was a pothole, correct?
That's right.
It was
Well,
something that had to do with.
there was a-
It was a maintenance issue.
There was a deviation in the pavement. As counsel for the appellant announced, whether it's a pothole or not doesn't really matter, to be honest.
Seems like it does, but.
I don't think it does, Your Honor, because, and the reason is,
Something that you should maintain, there's something that degraded over time or whatever, that you should maintain. It seems like these cases seem to say open and obvious doesn't take away the duty to maintain if it's that kind of a condition.
well, I disagree with you, Your Honor, because if you look at the last case on point that came out of this court, it's the Dampier opinion. It's the most recent one, 2012. Most recent case.
Was that Dampier?
Dampier versus Morgan Tire.
That was the stump in the.
That's
Walking through a
correct.
planter,
See, that
right?
was a place where people aren't supposed to walk.
But what's clear in the law here is not only in the
What's
fifth.
clear in the law is, and I think the Supreme Court has ruled on this, we've ruled on it a number of times, is if you have an open and obvious danger, that it may negate the duty to warn, but it doesn't necessarily negate the duty to maintain the premises in a safe condition, especially if you're a business invitee. And I don't even think that this is an element that's necessary, but you directed the business invitees in the area of the danger where they had to go. And so I think the case law is clear that open and obvious dangerous doctrine, regardless of whether you directed them in that direction or not, if it's on your premises, you have an obligation to reasonably inspect and to make sure that the premises are reasonably safe for business invitees to traverse. And I think the case law says that entering summary judgment in a case like this is erroneous because you've got issues of fact for the jury to decide. The jury may well say that it wasn't a dangerous condition. The jury may well say that she knew and that she's 100% comparatively negligent, and give a verdict of 0 in your favor. But it seems to me like it's for the jury to decide all of these issues.
It's a comparative fault issue, I think.
The case law doesn't support that, though. And again, we're going back to Dampier. Dampier was a failure to maintain. Failure to maintain was raised in that case, and the court granted summary judgment, which was upheld by this court en banc.
But Dampier even says in dicta that the open and obvious doesn't obviate the duty to maintain. The trouble with that case was the guy was walking through a hedge where you're not supposed to walk.
The issue, though, if you look at all the cases, including the ones that have been decided by this case, is taking the anomaly or the issue or the condition, whatever it is a fact by fact, case by case analysis.
Correct.
And so what Judge Parsons did in this case was he evaluated the record, as he's responsible for doing.
He made a factual decision, did he?
No, he didn't make a factual deciabsolute decision. No. Because
Sounds like he did.
the law says that it can be so open and obvious that that it absolves the property owner essentially.
Well, the record doesn't even support that it was so open and obvious, because I think the injured party in this particular case said that she was walking and didn't see it.
Right. And the case law.
And you directed her in that direction. She really didn't have any alternative but to follow the direction and go in that way.
Well, I would disagree with you, Your Honor. She could have gone the other way towards the night depository, which she said.
There may be I grant you that there are instances where the courts have said as a matter of law. For example, if you go into a house and you have a stair and a change of elevation and that sort of thing. But this is something that's completely different. You have a business invitee that was invited on your premises, directed in a direction for her to go. She followed that direction and encountered what you concede is a dangerous condition and injured herself. And I'm just simply saying that I don't think that negates the duty to keep the premises in a reasonably safe condition. The jury needs to decide that issue, not the trial judge and not us.
Well, according to the case law, again, going back to Dampier, This is an issue, and
The
even
case
it,
law is, the Marriott decision, I wrote that opinion. It says that the open and obvious dangerous doctrine does not necessarily negate the duty to keep the premises in reasonably safe condition when you have a business invitee. I wrote other opinions that say that.
I'm very familiar with all of your opinions, Your Honor.
By all means, criticize them if you want, but, they're there and we have to follow them, right?
That's not my intention to criticize your opinions, Your Honor, but I'm very
Go ahead, if that's what, and I think those opinions basically follow the lead of the Florida Supreme Court that basically says the same thing.
The way that I would respond to that, Your Honor, is understanding that the opinions that you have written essentially tend to find genuine issues of material fact. That is the standard here that's applied to this case
Right.
too, based upon the record.
That's all, that's what I'm saying. I think that based on this record, there are genuine issues of material fact that precluded the trial judge from saying that the open and obvious dangerous doctrine necessarily negated the duty to maintain the premises and say, you may go to trial and the jury may say, well, she should have seen it, she knew it, she was 100% comparatively negligent. Boom, that's the end of the case. And if that's what the jury decides, that's their decision. But the trial judge shouldn't be deciding that whole thing.
When you look at the record in this case, Judge, there is no dispute as to the open and obvious nature of this let's call it, anomaly or condition. There's none. The plaintiff even conceded that it's open and obvious. If she had been looking, she would have seen it. That's the importance of that testimony.
And if that's the case and she's comparatively negligent, the jury needs to decide that, I think. Anyway.
Do you have any cases where, I think the Circle K case may fall into it.
Sure.
Where somebody's walking where they're supposed to be walking and encounters a dangerous condition. It seems to me that the other cases, the planter cases, the tree and the planter, all those, somebody's really going where they're not supposed to. I mean, the court one place says you wouldn't expect a grown woman to do a tightrope act down the logs and stuff like that, where she maybe got snagged by a nail. But other than that Circle K case, are there other cases from this district, especially where somebody's walking where they're supposed to be and encounters a dangerous condition, and we have found it so open and obvious that you don't even have to maintain it?
Sure. I think Gorin versus St. Augustine's another opinion from this.
Warren was a case that I think really was a case of active negligence, because you had a tram that was taking passengers and unloading them in an area where they had to step off the tram, and either they stepped onto the curb, or if the tram happened to be a further distance away, in that particular case, the person stepped off the tram, misjudged, and fell. And all that case said was sidewalk curbs are open and obvious and is a matter of law.
Right, there's a long line of cases saying when you come to the edge of the sidewalk to the road, but regardless of whether you come from one or the other, you can expect a difference in level. That's not really a defect. I'm talking about here where there's some kind of a defect, pothole, whatever you want to call it.
I don't think the Gorn case helps you much.
Well, I think that it does only to the extent that it re-announces the rule of law, which is really what we're dealing with here. We're dealing with the open and obvious nature, and to answer your question, Judge, I apologize. The case really that we rely upon is Circle K. That's the case that we rely upon in our briefing as well. But I think, again, and not to be redundant, but getting back to Dampier, and I understand clearly the distinction, factual distinction. But again, all of the case law from all of the districts is concise in that this is a case-by-case analysis. So what is the court asked to evaluate on a motion like this? The anomaly at issue. It doesn't really matter if it's a planter. It doesn't really matter if it's a pothole, if that's what you want to call it. Because here...
Well, if it's a condition that you should fix, that's the issue, I think. It's something that's degraded over time, it's out there, it's open and obvious, and it didn't get maintained properly, as opposed to a curb that just the way it was built. Nothing happened to it. I mean, I think that's the difference. It's open and obvious to your client too, and the idea is they're supposed to fix it. They didn't.
And respectfully,
but maybe they did. Maybe just it has to do. Maybe they aren't liable too. I mean, maybe it only been there an hour. Those kind of issues. But it's the maintenance part that I think the problem.
And I respect that, Judge, but I think that's a little bit of bootstrapping, to be honest with you, because the premise of the motion and the premise of the law is, was it so open and obvious that it was inherently dangerous. And that's the standard, it's inherently dangerous, not whether it should have been maintained. That's not what the law says. The law says, was it inherently dangerous? But even in Dampier, it says, if it was dangerous, which, I mean, you could argue, you could say, well, she fell in it and she tripped and she broke her ankle, so it's dangerous. I mean, I'm not conceding that, but I could see that argument. But at the same time, even if it's dangerous, if it's so open and obvious, summary judgment is appropriate in favor of the defendant. And that's exactly what I mean, all of these cases, if you look at the cases from the 5th District, which Your Honors are clearly aware of.
If that's the case, and Walmart, Sam's, I mean, any business can just leave dangerous conditions on their premises, knowing that they needed to be maintained, but so what? They're so open and obvious. If people come and they're injured, so what? Who cares? It's open and obvious. They're supposed to see it, and they're supposed to avoid the danger, even though the danger's on our property, and even though we know about it. Does that even make sense to you?
No, Judge, and that's not what I'm saying. What I'm saying is that this type of anomaly is so common and ordinary. I mean, even in the Winn-Dixie case, which clearly went the opposite direction, because there was testimony here in that case that there were potholes.
There are cases that say that even if a condition is open and obvious, if you are reasonably aware that people are going to be injured by it anyway, then you're not protected by the open and obvious dangerous doctrine.
Understood, and there's no record evidence that we had any knowledge of it.
Well, you had
in this case.
had an arrow pointing the business of ITs to this area, and I think you have an obligation to at least reasonably inspect to make sure that your premises are reasonably safe for business of ITs to come on the property and not be injured. I mean, the law is clear on that, I think.
And I understand the court's position on that, but
All right.
you know, again, just. I guess my time is up.
Yeah, you need to let your
So I'll let counsel,
opposing counsel
take the reins here, but I'll rely on the cases in my briefs.
Thank you.
Thank you.
Good morning, Your Honors. My name is Derek Angel. I represent the third-party defendant, Lee Williams. My argument is also is the same as Mr. Ming's, Marx's client.
You're the one that put up the arrow directing these people where to go towards the danger that's open and obvious, right?
Well, actually, Your Honor, there is no record evidence to that effect. There's no evidence at all of who
your client is who again? What did your client do?
Posturally, the plaintiff initially just sued the bank, who then added a Bob Ray defense.
Tell me who your client is again.
Lee Williams is the name of the company.
They were actually doing the work, right?
You're doing the work, right?
And Kirby hired you?
Yes.
Okay.
You're saying
arguing for both, though, right?
Yes.
You're saying you didn't put up the sign.Ey're saying that they didn't put up the sign. You're saying did you put up the arrow?
You're saying you got no duty, right?
There's two questions.
A lot of stuff, right?
Yes.
Did you put up the arrow directing the people?
There's no evidence as to who put up the sign. It could have been the bank. It could have been either client. There's no evidence whatsoever to that effect. It was never established. We have a very limited record here. Right. And the record is that the deviation was at least 10 feet away from where she fell. Right. And and there's no evidence whatsoever that we had any obligation, control, maintenance of the pavement outside of our work area. And so the additional basis for affirmance that applies to us is that this was outside of our area. She testified that she was 10 feet away and that we have no obligation or even ability to control this.
Y'all orally argued at the summary judgment hearing that you had no duty owed to her.
That's right.
That was not in your written motion for
That was
summary.
in your motion?
That was not in the motion, Your Honor, and that's their main objection.
You were riding PNC, weren't you?
We were on the papers, but not at the argument.
Well, I guess my problem and their problem, and apparently my two colleagues, I mean, when you look at Rule 1510, the motions shall state with particularity the grounds upon which it is based, and the substantial matters of law to be argued. Right. And I see they've now changed shall to must. In case we didn't understand shall, now we know must means must. Yeah. And you know, I understand you can waive the 20 days and this, that, and the other, but you know, the whole idea behind summary judgment is everybody knows ahead of time, here's what the issues are, go find whatever evidence you can and go forward. And I don't know how y'all get around that, quite frankly.
Two answers to that, Your Honor, and I think that is the general rule, and there's a reason for that rule, is because in summary judgment, of course, here's my evidence. You have 20 days to say, here's my evidence. And so it's not fair on appeal to say, well, we would have argued this other basis, when the appellant would say, well, hold on, if you had argued that, then I could have presented my witness, right? In this case, what happened? The alternative basis was argued at the hearing, which is different
But
than...
it wasn't noticed.
It wasn't noticed, but it was argued.
Big difference.
It is, but if you look at the Loranger case, which is their primary authority on this point, it says that the alternative basis was raised for the first time on appeal.
But the
And what-
judge kind of shut you down, though. That, you know, if y'all had argued it and they hadn't objected, then it's kind of like trying it by consent. I mean, that's kind of how I analogized it. But here, rather than the plaintiff's counsel shutting you down, the judge goes, now hang on, we don't need to hear that. Y'all are just here on the open and obvious.
That's
right?
true. However, there's a key fact here, which is that when the judge asked them, what are they doing in the case? The answer was, we don't know. So in other words, there was no other evidence in the world they could have presented had the argument been properly raised. And I think that's why it's waived. At this point, we're talking about, they're asking for a remand to conduct discovery on really an unpled theory when there is no evidence that they're aware of that would show that we were negligent in any way. Let's not forget their own answers to interrogatories from Kirby said, what negligence led to your injury? She said none.
Just because you filed a motion and we say you did a motion for summary judgment and we say you didn't succeed this time, you can file another one and get it right. Put it in there. Whatever you want to argue, make sure you put it in there, right?
That is correct, but at this point, it's their burden to show that there's error as to our clients as well, and at this point, by their own admission, I think it amounts to a fishing expedition if we go back down. They're not aware of any evidence of negligence on part of our two clients. So
Okay,
I'm
your
not,
time's about, it actually has expired.
thank you, Your Honors.
Do you want to say anything else?
No, Your Honor, I'll rest on the contents of my brief.
Okay, very good. Wise to take the hint.